Good morning and welcome to the latest edition of Petexia's IP for IP Matters webinars. Today we have with us Sudhi Tronson, who's going to be speaking about IP for small and medium enterprises. We're very lucky to have Sudhi with us today. She's the founder and principal at STLG IP, a boutique technology law firm in Silicon Valley. Sudhi has 25 years of experience in law, technology, and management, and her firm specializes in all areas of patent and trademark preparation, as well as prosecution and transactions. So without further ado, I'll switch you over to Sudhi and let her get started with today's webinar.
Good morning, everyone. Thank you, Zoe, for the introduction. As we're going to be discussing today, some basic principles of intellectual property for SMEs, and I understand from what Zoe has shared with me that many of you are already experts in the field. So I hope that some of the basics won't bore you, but they might be useful to your clients as you're discussing matters with them. And then some common observations that I have learned in practicing in this area, as well as from other people that I have come across that I'm hoping may be of value to you. As usual, go first, given that we are all, well, some of us are attorneys, especially myself, with the disclaimer. This is just educational. None of the slides are meant to be comprehensive in nature. So I do hope you keep that in mind. Generally, what we are going to discuss are types of IP, some definitions, some strategies, vulnerabilities that especially SMEs may encounter, given that they are not necessarily equipped with a full legal resource at their companies. Some questions that one may want to ask as, let's say, some litmus tests as to, well, could I have an issue as it relates to intellectual property? Should I consult someone? And some mitigation. How can you mitigate risk? And how can you mitigate costs, especially when it comes to patent area? A lot of the smaller companies, and rightfully so, they like to know, how can I get this patent application done or get the prosecution done at a lower cost? So given that attorney cost is usually the biggest factor in usually most IP work, including transactions, of course, there's some things that companies can do to help drive down the cost. Zoe, are you okay with you going through the slides?
Yes, we're there.
All right, thank you. So if you think about the question of what is IP, is any new idea, discoveries, invention, concepts that are results of an intellectual endeavor. They are a property just like any other sort of real property, except these are creations of the mind. So they can be owned, bought, sold, rented, destroyed, improved, just like any other physical property that one may come in contact or have possession of. With respect to intellectual property, there are some reasons why people want to acquire them and have the rights to them. They can be used as in an offensive manner to protect the market. So if a company's IP strategy is market-centric, that is what you usually use that in an offensive method. Conversely, if you're trying to protect your own product, and if you're a product-centric, you may be choosing, that would be a defensive use of your intellectual property. You can use your intellectual property just like any sort of property to generate revenues through licensing, sales, etc. For SMEs especially, it can help enhance their valuation for financing, M&As, and the like. And the last two, which some do, but it's definitely not the concern of the SMEs, is for marketing and reputation, and the whole thing about employee morale at a company. But the first four that I just mentioned, those are the biggest things that make intellectual property have a value, especially when it comes to SMEs. So what is IP? When we talk about IP, we're talking about a general umbrella term. And it covers a series and a numbers of interrelated doctrines of law. The major ones we usually hear about when we talk about IP are trade secrets, copyrights, trademarks, and of course patents. But then, as you can see, there's a lot more involved that could fall under copyright, under intellectual property, including moral rights, which has to do with the likeness and the value of, let's say, a celebrity's picture or his or her liking, let's say, in a video game. So there is more than just the ones we usually talk about, but what I like to refer to are the Magnificent Five, which are the patents, copyrights, trademarks, registered designs, or what we call design patents, and trade secrets. So if you just look at it from a general perspective, as you're talking, if you're an SME or if you're engaging with your SME clients, patents are directed to new inventions, and you basically have to apply, get it examined, and then hopefully receive that patent granted to you. Copyrights have to do with original, creative, and artistic forms, and they exist automatically, although you can also register them with and get some federal protection. You got the trademarks, which has its own family of categories in that group that we call trademarks, and they have to do with distinctive identification of products or services. And in the US, and I want to make that emphasize that we're talking about the US in this situation, they can be created based on use and or registration. Then you've got the registered designs, which are protections for the external appearance of a product. And you have to, again, just like utility patents, you have to register that. And you've got trade secrets, which is valuable information, which is not known to the public. And you have, the way you acquire that right is usually by exercising reasonable efforts to keep it a secret. So that's, in general, what I would consider the Magnificent Five within the IP. Now, why should you care, and who should care about IP and why? So the issue of IP comes along for various types of entities in various types of situations. When you're talking about a corporation, we could be talking about who owns the intellectual property. In a commercial transactions, let's say if patents are involved, what do you need to know about the bar dates, deadlines, and ownership? Commercial litigation, similarly, what are they worth if you're going to be litigating a patent? Wills and estates. What happens to an IP intellectual property when the owner passes away? What must a trustee know about maintaining patents? For startups and in business development, the issue is how to protect your clients' ideas, making sure they're not infringing somebody else's IP and the like. We talked about the litigation a little bit, and how might you have to handle or advise your clients if they're getting into an IP litigation. And similarly in divorce and family law, if somebody were to get a divorce and they're a founder or they're owner of an IP, how do you divide the IP assets? So one thing that I always, and it's easier when you advise a client than when you're trying to exercise it yourself, but the whole thing being is that it's easier to get things done early in terms, especially when it comes to IP ownership. You cannot afford to be shy about asking for clarification and the proper documentation. And usually what I advise is I blame it on the attorney. If you have issues or you feel uncomfortable talking with your founder or co-founder about, well, let's put this in writing as to who owns what and what happens if one of us gets a divorce, or if one of us passes away, what happens to our interest in that intellectual property. And that is also of great importance, especially for SMEs, also because if they're also going through any kind of a funding, there's going to be due diligence done. And if the record is not clean, they're gonna run into problems. So there's a value process for intellectual property, just like any other thing. So a new IP that you have, it has to propose a value that makes sense. It has to work in reality. You have to have freedom to operate. Now, how you get the freedom to operate is a different question, of course. You might get it through co-license, cross-licensing and the like. Most often, not always, it has to be patentable. There has to be a commercial market for this product, And most important, and I run into this question often, especially with a lot of younger startups, is that someone has to want to pay for this thing. Someone has to be willing to pay for this. Otherwise, from a commercial perspective, the IP may not have much success. Now, just like if you were to leave your Rolex watch on a park bench, if it has value, people will follow it. They will follow it and will want to grab it very, very fast, and they will also try to do design rounds. So again, that's where the protection comes in, and why you need to be aware of the property that you have so you can exercise the proper protection methodologies. And you need to be able to build a company, create products, and generate profits, whether you're licensing the IP out or you're using it to manufacture, and also receiving royalties. So a typical strategy for a SME you can divide it up in two ways. One, you could call inward looking, and the other one you could call it outward looking. Inward basically covers protecting the intellectual property of the SME itself, whereas outward looking has to do with the strategy and the effort that takes place to determine whether the SME will be infringing anybody else's intellectual property as they develop and market their products. So these are two different ways of looking at the strategies that you're creating them for the SME. But then there's a lot of ambiguity, and there's a great opportunity for confusing these two different strategies. So that is something that I always like to emphasize, that please keep them separate. They use a lot of same resources in terms of analysis, evaluation, and search, but they are really different strategies. So as you're advising, if you're an SME or if you're advising your SME clients, what are the first two steps? I would say identify and deal. You need to be able to identify the existing, the current, and potential future IP rights, and you need to know how to deal with them. Whether current, future, it doesn't really matter, but you need to identify, you need to know what to do with that data. Otherwise, it's really just a lot of data, but not a lot of information. And because a lot of the IP rights come to existence without, the creator of the IP not doing anything affirmatively, sometimes, the SMEs may not be aware of the rights that they have created or the rights of others that they may be stepping upon. So the question becomes, can you identify the core intellectual property of your company and then articulate a plan to protect, grow, and potentially leverage the company's IP? So these are a series of very logical steps that is very useful for the companies to go through as they are looking at their overall business strategy, because the IP, again, is not just an overhead content or expense, but it's also part of the assets of the company, and it's a little bit more challenging than counting the chairs and the tables. So you have to really pay attention to the defining, protecting, growth, use, and monetization components of your business strategy. Now, the IP value can be exploited by the SMEs in, what we could call direct and indirect. The direct could be, for example, if you're licensing it, you're selling it, you're using it as an investment collateral, which happens, and if you're actually suing somebody to get infringement damages, and that's the value of having an IP, so you can do that. Indirect would be if you're going to use it to have spin-offs, partnerships, and joint ventures. Now, let me give you just an example. Let's say you're a medical device company, and you're looking at the IP and how it affects, or how does it come about in the various stages. Typically for a medical device company, if we were to break it down, there's a concept phase, there's a prototype, preclinical, clinical, manufacturing, marketing, and commercial use. So each of these various stages might trigger different events and different considerations that the company has to keep in mind as they are moving forward. For example, During concept phase, you might be concentrating on confidentiality, ownership, when you do your employment agreements and when you have the contractors that come. And you might also want to do an IP analysis early on to see what the landscape looks like from a technical perspective and intellectual property perspective. And they are different, but they can certainly be merged to give you a better picture of what's going out there. When you get to the clinical stage, you may at this time choose to do a more comprehensive freedom to operate analysis to augment your earlier findings in earlier stages. And you have in later stages, you might want to think about custom protection, for counterfeits and the like when you're in the commercial stages. So different companies may have different strategies because the way they get into the market is different. But for each one, there is a series of well-established ideology and steps that we can all learn from each other so that you don't have to reinvent the wheel because you don't get any value out of doing that. So now let's take a look at a company that is a technology company with a website. They have a service or a technology that they offer. And I'm not talking about, I'm sure you all know about the Alice case, and you're not talking about just a simple e-commerce or business method transaction here, but we're talking about even a company that has great technology behind the software, and they're delivering it through a website. So technical innovations relating to this e-commerce system could be protectable by patents. Your HTML code, your software could be protectable by copyrights or trade secrets. Your web design, your graphic symbols and the like could be subject of a design patents. Your graphic user interfaces, as you know, for example, Apple and Samsung have had a lot of dispute over the appearance of the icons, for example, on an iPhone, so there's value in that. The creative website content, copyrights, again, databases you may have, copyrights, and business names, product names, logos, domain names, and other signs you may have and taglines could be the subject of potentially trademark protection. Now, common mistakes that are typically done, we're going to go through several different slides, each of them with a different flavor addressing that, but IP mistakes are quite expensive. Every mistake is expensive to fix, but with IP, some things you can actually fix them later. Like, for example, if you have a premature disclosure of your patentable idea, you will lose the right to patenting that everywhere in the world. Of course, the US has a limited 1-year grace protection. But some of the typical IP mistakes could be use of third-party trade secrets, adoption of trademarks owned by third parties, failure to file patents early, failure to obtain assignments from every employee, early on, and exclusive outbound licenses in critical fields. So you need to, again, think about how you want to structure your intellectual property as it relates to licensing of that intellectual property. To give you a real example, these days would be, let's say, trademark. I've had several clients just in the last year alone that we have, on their behalf, my firm has done takedown notices to Apple, Store, App Store, and Google Play, because the company whose, major value of what they have is the name of their app that they're using, infringe on the client's trademark. Now, as you know, in US, you don't have to even register a mark to have trademark protection. Under common law, you can still assert that protection. So now what happens to this young company that did not do just a simple due diligence to see who else has, let's say, a similar app prior to them in similar field, which could then result in confusion as to the source? Then they have to change the name of their app. Now, after 2 years building the brand name, and they have nothing else but that name recognition, that's pretty expensive, I would assume, and could be detrimental to the continued success of that company. Some other early considerations are really identify whether your IP relies on IP what kind of IP, and then make those decisions early on in a timely manner. Understand your targeted market and devise a strategy. Have effective agreements, and I want to emphasize the word effective because not every agreement has the same power and impact, even if it's of the similar nature. And make sure you have it with everyone. Don't be shy about making sure that your agreements cover everyone, from founders to co-founders to contractors, consultants, and everybody else. Do understand the impact of regulations on your entry to the marketplace, and know the differences between patentability and right to use, which is one of the areas that is most confusing for a lot of companies. Now, let's just cover very briefly about trademarks. As we said, trademarks are meant to identify source of a product or service, and it's meant to distinguish it from the source of a competing process, service or product. So, and that is the idea behind a trademark, distinguishing the source. So the consumers know what the source is. Now, it could be a word, phrase, symbol, slogan, design, or combination. But also there are some non-traditional trademarks that some of us may not be familiar with, which could be a color, scent, sound, motion, and trade dress, of course, is also for product and or packaging design, which could fall under the trademark categories. So there's a range of types of things that could be subject to trademark protection. Now, as we said, in the US, you can establish the rights to a trademark under common law, which is based on usage. And also, you can register that with the trademark office. Now, if you're registering it with the trademark office, you can file an application, as you know, even if you are not actually using it, and you can file it as an intent to use. And then you can get the mark allowed and everything else, and then you have to provide proof of actual usage in commerce, and then if everything goes well, then the office will actually register and issue a registration of your trademark. And that carries a lot of benefits in addition to what is available under common law protection. And after a period of time, you can actually request that it's incontestable, and that carries a lot of weight. Again, additional value if you have other companies that are using either the same or confusingly similar marks. And again, you will have a great upper hand in removing that trademark from the marketplace. Now, again, remember that in US, we do have this based on usage protection, but that is not the same for everywhere. In many other countries outside of US, is actually whoever registers it first. So you have to be careful and take into consideration what markets you want to go into, and actually, if it's of value to you, making sure you get that registration in those other markets, because if you actually build enough of a traction, guess what? Other people will register that mark in their countries or some other country, and then when you're ready to enter that country, you will not have access to that trademark. Apple had to do that, I think it was in 2012, for iPad. So they had to pay, I don't know, a great sum of money, maybe 60 million, or it was quite a large sum of money to get the rights to that trademark in China. So knowing how you want to enter the marketplace and where you want to enter that, again, is of great importance when it comes to your trademarks and some of the other IP types that we'll talk in a second. So when are some of the times, again, that issues relating to trademarks may come up? Company organization, if you have a new line of product or services, an example is the app that I just mentioned. If you're doing comparative advertising, you're using AdWord campaigns, business expansion into new geographic markets we just talked about. In licensing agreements, there is an IP, you can license it just like anything else. In the business evaluation, these are portfolios, there's a great value, especially in the consumer market, for trademarks. Cyber squatting, using others' trademarks on your site. I have seen a lot of places where they use other companies' logos just by having, let's say you have had somebody speak at an event that somebody has hosted, and then they continue to actually use the company's logo on and on as though to give the impression that that company is a partner. No, they just had once somebody who works there speak at an event that was hosted at this venue. So you have to be very careful about that as well. And I want to emphasize lame names. A lot of times people pick very silly names that really have no marketing value. And also as they take it to other markets and other languages and other cultures, they will actually not be a good way of for representing your company using that mark. When it comes to copyrights, basically copyrights are meant to protect, it provides protection to authors of original works of authorship, which are fixed in a tangible medium, and it's usually for literally dramatic public performance, sound recording, visual arts, technical drawings, and the like. That's what it covers, and it protects the original author from somebody else copying or reproducing the work, publishing it, performing it, and so on. When are the typical times that copyrights issues may come about? If you're copying and pasting from the internet, if you hire an artist, graphic design, or web design firm, attaching videos or photographs that are not yours to a website, displaying other people's copyrights publicly, sometimes playing music at events, mimicking someone else's creation, linking. You've heard of word linking versus deep linking, framing, giving the impression that is coming from you rather than it is from another website. You're just making reference to that. These are some common mistakes that sometimes people make just innocently, and sometimes they think they're being clever doing what they're doing, but they're just actually exposing themselves. And usually, the risk reward is really not that great on the reward side. Trade secrets is any information that is a secret, has a commercial value because it's a secret, and is the subject of reasonable efforts by the owner to be kept as secret. So you have to exercise all of these factors have to be present to make a trade secret a property that you can actually protect and go after people. Usually trade secret issues arise when there's an inadequately drafted agreements in licenses and assignments, read trade secrets, employee handbooks, confusing or not paying attention to the difference between non-use versus non-disclosure. Non-disclosure is what typically gets put into a confidentiality agreement, but most people forget to put that, hey, not only you can disclose it, but you also can use it for anything outside the scope of this agreement. In joint ventures and third-party investments, it can come about. Licensing and distribution agreements when you have a new hire, and also third-party theft of inventions and technology or know-how, usually is by former employees, and failed business dealings. I once heard a quite successful CEO who, actually he didn't do anything wrong. They had just, they had sold their company and everything else. And he had a stock portfolio. And one time he told me, he said, it's not hard to find sometimes what people are about to do. All I had to do for this other company, just go there on the weekends, drive by on the weekends, and if the parking lot were full continuously, I knew something was going to be up, and I had heard rumors of an IPO, and lo and behold, they did have an IPO shortly. So there is a lot of things that, yeah, we can control who parks in our parking lots and how employees come in and go, but there's a lot of other ways that we can protect the trade secrets, like not discussing them in a restaurant or in a public setting. With that, we'll move to what is usually the part technology companies focus on, which is on the patents. Now, patents, sometimes for people who are new to it, usually cause a confusion as to the kind of right that it provides. In that patents provide a negative right. It's not a right you get to have because you got a patent issued to you, but it's a right for you to exclude other people from doing whatever your claims are setting the boundaries around for people not to do. So this is what we consider a negative right. Trademarks, you actually get the right to use your mark. You have your mark, you use it, and you can also stop other people from using it in a confusingly similar, manner. When it comes to patents, you get a patent issued, but it doesn't give you the right to actually make a product according to whatever the claims are. It just gives you the right to stop other people from doing that. So that is the outward-looking nature of, let's say, looking at patents. It's the only way to protect a technology that is disclosed, assuming that it's patentable, that is, it's novel, that it's non-obvious, and there's appropriate and adequate disclosure, which covers and satisfies the statutory requirements of enablement, written description, and illustrations. It then is the only way to protect the disclosed technology. But what is also important to remember that is territorial. That is, every patent is only good in the jurisdiction in which it has been given. So a US patent is only good in US, a Japanese patent is only good in Japan, and the like. Of course, we do have in our statutes that we can also use the patents to stop other people from importing into the US patent, products and the like that are subject to a valid patent. So in that sense, you can play somewhat against international importers or international products coming in, but it's still within the US what you can do, and it can play a big role in how, for example, you draft your patent claims. At the end of your patent, the grammar becomes sometimes very important, especially if it's a method type of claim, where you better use a passive or active verb. Could make a big difference as to what steps are taking place in this jurisdiction versus, let's say, somewhere outside of US. And those are some items that are a little bit more technical and outside the scope of today's discussions. And then, of course, there has to be utility. You have to file things on time and examine it and so on. Yesterday, actually, I was talking to a prospective client, and they had licensed for a lot of money. And they were still paying minimum royalties because they hadn't commercialized it yet. A lot of money for a patent and probably some trade secrets. I don't know. That's still yet to be determined. But what they hadn't paid attention to was that all of their activities were taking place outside of US. So this client, even though it's a US company, they had set up an overseas company. They were doing everything overseas. Yet the patent they had licensed was a US-only patent. Now, had they paid attention to the fact that patents are jurisdictional, and let's assume that there were some trade secrets along the way also that were being licensed, they could have probably done a better negotiation in terms of the royalties that they're paying, or even these minimum royalties. So it can have grave consequences if you don't pay attention to it. Now, the types of patents, most of us usually don't care about the plant patents in our line of business and technology, but they can, there's two other groups of design and utility, and design patents can be quite important in the IP portfolio that you may create in your company. And then, of course, we go into the utilities, which cover how things work rather than how things look. Now, utility patents can be used to protect things like process and methods of making and using a machine, apparatus, or article of manufacture, as we call it, composition of matter, and improvements. And almost most patents are actually improvements. But of course, they can't protect laws of nature, natural objects, natural phenomena, mental processes, abstract ideas, and the like. And as we know, post-Alice decision last summer, just purely business methods are not going to cut it either. So, okay, so here you are. You either have started a company or you're about to start a company. You need to create your patent strategy just like as part of your business strategy. It's not a different strategy. It's just a component of your business that you need to do. So what are some of the things you have to do? When I hear pitches from different companies during some competitions, competitive assessment is usually really critical, and most pitches don't really include the good competitive analysis or assessment. What's out there, who's doing it, what's the barrier to entry, and the like. And all of that can be done or through patent evaluations. You need to know what's the portfolio of your competitors, what do they have. Monitor patent filings in markets of interest. Now, this may not be as critical to a very young company, but if a company already has some traction and can afford it, definitely monitoring patent filings in markets of interest is really important. Assisting in making decisions regarding the patent protection, identifying the competitors' business strategy. You can do a lot of that by doing some pretty decent job at competitive assessment, and you can looking at for example, patent filing trends of a company, product trends, marketing information, and PR. You can figure out what their business strategy might be for one of your competitors. You can identify potential acquisition targets through doing patent studies. You can also make yourself a potential acquisition target if you were interested in, let's say, some big company acquiring you down the line, and that was one of your exit strategies. You can find out from doing their patent analysis what direction they're going, and hopefully be able to interject your patent strategy and the type of patents you're filing in that roadway and in their path, so you become of interest to them. So what are some of the times when issues may arise with respect to patents? You have an idea for a product or service. The question may be, do you own or work for a company? Because who owns any patent rights that there might be? Publication, you're going to go to a conference, you're going to present. Are you going to lose your rights if you haven't filed for a patent protection yet? Are you involved in R&D in any patentable field? Do you import or export products, as we just talked about? Insufficient disclosure in the application. That is one of the major problems that I see with a lot of the younger companies, is that they believe anything that they disclose is going to give them a good priority date, and that's not the case. And I've actually seen people who they filed very inadequate patent applications, and thinking that they were protected, that they had already filed, they went and disclosed their idea to other people, this time a little bit more completely. And so they more or less lost that right because they had disclosed it, especially in the overseas market. As I mentioned, in the US, there's some limited one-year grace period. And so then by the time they consulted an attorney, time had come and passed. So they basically lost everything in terms of that particular intellectual property that they had. So if you're looking to identify some potential vulnerabilities, is that if an SME is filing too late, if it has data to support the innovation and has not yet filed a patent application, it may be too late. So it's kind of a game in a way that you have to predict when you're ready to file, and it's a continuous process where you have to gauge the stage at which you're filing. Or the SME has the data to support the innovation and has published that data without having filed a patent application. And also keeping in mind that even when you file a patent application, that you have to have, again, proper disclosure. You need to be, so that you can commercialize it and get maybe protection to equivalence and other alternate embodiments. And a lot of people don't pay attention to that, okay, I shouldn't just be interested in protecting what I'm going to implement, but also things that are commercially feasible for a competitor to do, so that they don't come and take the market that I have created. And you need to make sure that your patent strategy is coordinated between the patent attorney and the company's management. Some IP issues that may come up with respect to ownership could be these are some of the examples for that. So each type of IP has different ownership rules, and the ways of documenting such ownership, there might be different results. If there is an agreement, let's say to the contrary, the inventor was hired to invent, and the founder has not assigned to the company what they have created, by law, the inventor is considered the owner of the patent unless there's something else that intervenes, like an employment law, employment agreement, if it has to do with, let's say, some coding or something like that. It might be different as to who owns what. So again, you have to be really careful because each one carries a different presumption, and you need to make sure you have the right documents in place. Employee created work versus contracted created work, co-ownership. If you have more than one inventor, you will have co-ownership. So again, you need to be clear and understand that, what happens 5 years down the line if you don't have meeting of the minds within the two co-inventors and everyone wants to take a different path and they both own the IP. When it comes to work for hire, that's one area that is, I've seen a lot of mistakes in the assignment or in the language, in, let's say, a confidentiality agreement or some contractor agreement when you're hiring somebody to do work for you. In that work for hire, especially in California, has been found as a vulnerable area that it may actually provide for the person to have been your employee. So you have to be careful so that you don't use a work for hire clause in some of these agreements where you don't mean to actually say, provide that the person is your employee. So you have to use that work for hire clause very carefully. Also, work for hire is under the copyright provisions is for a certain classification. So by definition in law, for work made for hire, there is some 9 classifications that apply. So let's say when it comes to certain software development, if it doesn't fall into those 9 categories, it may not even be relevant. So you want to make sure that you are using work for hire versus assignment language in any IP that is created very wisely and carefully. So please, this is one that I would want to highlight, that you used great care in finding out whether you should be using an assignment language rather than just relying on a work for hire. Okay. One of the best practices is just do it right at the beginning. Clear the ownership of IP rights up front in an express written agreement between the parties, and please be aware of the grammar. This is one area where the commas, semicolons do make a difference, and even the biggest and the brightest of organizations and companies and universities have suffered the consequences of using improper grammar. For example, I'm talking about present tense versus future tense, the obligation of, oh, I shall assign these rights versus I'm hereby assigning these rights. So be please very careful. The impact of something being a covenant or a promise versus representation versus warranty in any kind of an agreement having to do with IP or anything else for that matter carries different results when it comes to how the agreement is treated. So again, you need to be careful about that. In bankruptcy and then licensing is also critical. One of the main things I see with respect to licensing of intellectual property is that sometimes the person who's drafting it is not familiar, not just with the legal aspects of the general terms, but also with having a good understanding of, let's say, patent law or trademark law. And they're using improper terminology or not adequate terminology, and it can end up being a problem again down the line. To mitigate risk, what I would advise is that you do an IP landscape study at the early phases of your development as part of your market research. Know at least the path of least resistance or design around options. A clear landscape may also help induce investment as you're seeking investment from venture capitalists or angel investors. Do a freedom to operate study once the product and the service is known. Again, because for a freedom to operate, you actually need to know the features of the product that you're going to put out. That's the best time to do that. Whereas doing a landscape study gives you the general flavor. The freedom to operate gives you a more exact information. and conduct a detailed study of the claims and the disclosure of other relevant patents so that you are not infringing other people's intellectual property. And then to the extent that it's necessary, get the non-infringement and invalidity opinions. Now, written opinions can be quite expensive because of all the precautionary language that has to be put in such documents, but most often you don't need a written agreement if you're trying to understand where you are with respect to others' IP. So again, talk with your counsel and make sure you come up with the best way of getting these things so that you're not paying everything budget that you have, spending it on an IP and not have a product to actually market. Now, moving on to mitigating patent cost. These are the things I would suggest. Without drawing a legal opinion, this is, my comment is directed to the companies themselves, not the IP experts on the call right now, is conduct a preliminary search, provide all of the information to the attorney at one time, minimize the delivery of information in a scattered piecemeal format, organize the content, because each time we all deal with so many different cases and matters. So each time we pick up a case, we have to reorient our mind to remember everything. So the less we have to go back and forth, and because the attorney billing is most often based on time spent, or what they anticipate the time is if you're giving you a flat rate, is to put everything in one bucket, share the information once so you don't have to go back and forth. That's what you can do to minimize costs. Disclose relevant art so the attorney knows where things are so they can kind of gauge where your invention might fit with respect to other stuff. That helps them, focus a little bit better in areas that they should be disclosing in more depth. Provide a complete and well-written invention disclosure. Too many times I see functionality or desired result rather than how you are getting to that desired result. And I rather spend some time ahead of time with my clients to make sure they understand what it is I want from them, so that keeps the cost of it down, because the more you provide, the more the SME provides, the less the attorney has to create on his or her own. Drawings, I can't say how important drawings are to almost all inventions that can be illustrated. Patent applications have been saved by drawings where something was in the drawing and it just didn't, the inventor at the time didn't think they were important enough to include it in the written documents that were provided, and the attorney didn't put it in the written portion. So drawings are not just an extra part of the disclosure, they are part of the disclosure, and they're really critical. When it comes to giving feedback to your attorney when they're sending you a draft up, give it in a timely format so the 2 months doesn't go by and they've forgotten what they did for you. They have to again go back and revisit everything. So timely feedback while things are fresh in the attorney's mind. Do let them know your business strategy. Your attorney is not your CEO, obviously. They're not making your business decisions, but if your patent strategy and your IP strategy is part of your business strategy, and if they don't understand your business strategy, they can't really protect you the best way possible. Know your filing strategy early on, because before you know it, the 1-year time frame comes up, whether it was a provisional you filed or a non-provisional, where you have to decide on your international filing, and that starts one set of expenses, which is not necessarily the worst, about 5 to 7K to do a PCT application. But then shortly thereafter, you're going to start having to make decisions for national and individual jurisdiction, and that the cost can be quite heavy at that time. But also knowing your filing strategy will impact whether you might choose the non-publication option when you're filing your patent application when you first file it. Often, if my client doesn't want to file international, we check off do not publish for the USPTO because that's an optional thing. And that kind of keeps everything in secret until the patent is resolved 2, 3, 4 years down the line. Sometimes, and most often, there's no reason why you want to alert your competitors as to what you're doing if you're actually don't need it to be published. But you can't do that if your application is going to get filed internationally. So to the extent that you can, you want to give think about those decisions early on. And then, of course, your budget. Zoe, how are we doing with time?
We're running a bit long, but we're good to go if you want to continue.
Okay. So we have a few, just a handful of more slides. One question that SMEs a lot of times ask is, should I file a provisional or should I file a non-provisional? The way I look at it is, with a provisional, you're going to save around $730 or so in government fees, okay? The difference between the two. You have also the cost of figures and drawings that you can save because they don't have to be formal. They can be hand sketched or otherwise. Now, I couldn't hand sketch if my life depended on it. So as the SME, if you can do that, that's great. That's all we need for a provisional. And any format is okay, but who these days actually, takes a picture of a note on a napkin? But, and we usually type stuff up. But that's also acceptable. But the major cost for any patent work is the attorney's time, which is his or her time, right? So then it really, once you do the 730, put it away, and maybe $500 in for figures, doing that formality. Let's say you're talking about $1,500 total as to those differences. The rest of the cost is attorney time. So what would drive that cost up or down is how much disclosure there is, how complete the disclosure is, and how well that disclosure is described, and complexity and everything else. So what I would typically say is that if you're going to file a provisional, okay, if you have a single embodiment, if you don't have everything identified that you want to go under examination, then maybe you may want to file a provision. If cost is not the major thing, in the sense that as this graphic is trying to convey the message, you've got bits and pieces at different times. Within 1 year, you collect all of that and you file it. Now, you have to keep it as a non-provisional. That's the circle at the 12 months. But you do have to keep in mind that every one of those things that you file on its own has to meet the statutory requirements of written description, enablement, and so on. So provisional is not the place for sloppy content or inadequate content, but it's for partial content. We're not talking about some of the strategic reasons that, let's say, a pharmaceutical company where every day matters in the life of a issued patent, but we're talking about general company, companies with general technology. So that said, do not make that decision lightly, and do not equate lack of formality requirements with the lack of the requirement for complete disclosure for whatever it is that you want to get protection. So I hope that's a little bit clear. Now, this one is just a very top level cheat sheet. So if you're looking at the various type of IPs or ideas that we talked earlier, you might want to ask yourself, well, does this idea have a utility? If yes, is it a secret? If yes, we'll keep it as a trade secret. If no, then you might want to think, is it new and non-obvious and so on? Then I might want to find a utility patent for it. Or maybe I don't care about protecting my own. I just don't want other people to stop me from doing the same thing I've done. So then you might want to just use it and publish it and not get protection for it. Another question might be, oh, this thing doesn't have a utility, so I can't really go down the utility patent route. But let me see, does it designate a source? If it does, then I could perhaps file it as a trademark. If it doesn't, then I want to think, is there a new aesthetic feature? If so, then I can file it as a design patent. And if none of those, maybe it's something that you can file or seek copyright protection for that idea. And of course, there's a big play between trademarks and design patents. So I'm not trying to say these are all distinguished and mutually exclusive means of protection. Rather that this is a very top level way of going through that. And lastly, if we were going to put into one simple general overview of different stages where they require IP review for you, you can look and say in a research development or a product launch or something of the sort, license and other agreements, I should really go ahead and review all my license agreements. When, as it relates to patents, if you're in a research and development stage, you're in the regulatory stage, especially, let's say, in a medical device where there's an interplay between your patents and your regulatory filings. You have a product launch and distribution, you have to be looking at patents. Trademarks and copyrights, again, for commercial launches, you need to be doing that. For your branding, you need to be looking at that, and so on for the trade secrets. So these are some just general considerations. Especially, again, for SMEs, it's important to keep in mind the differences between infringement and patentability, and also do some clearance search when it comes to your trademark, especially if you're in a low barrier to entry kind of a market, where it's people then usually jump the gun sometimes and launch a product with a name that should have been cleared ahead of time. So Zoe, if there's any questions, I'll be happy to entertain them. And of course, I welcome anyone who has a question to contact me offline as well.
Okay, thank you so much, Sudi. We did not have any questions come in through our social media channels at the moment, but we often get them later via email and such. So I'll definitely follow up with you. With any of you who want to email us with questions, please feel free to contact us via social media at Petexia, or to send us an email, and we'll get those questions over to Sudi and get those answered for you. So I want to take a moment and really thank you very much for a fabulous presentation. I certainly learned a lot, and really a good thorough overview of how to come up with a concise and a wise patent strategy for you as a startup or a medium enterprise as you're getting going in the industry. So thank you again. We really appreciate it. Tune in next month for our next IP Matters webinar. It's going to be covering technology licensing in Asia with Stella Poon, who's with the Hong Kong Trade Development Council, and with Danton Mack at Leach Tishman, another IP law firm. So they'll be covering that for us on October 15th, as usual, on a Thursday at 10:30 a.m. Pacific time. So I look forward to seeing you all there, and thank you very much, Sudi, for a wonderful presentation.
Thank you, Zoe, and thank you everyone for attending.